For judgment, item number 1.
Yes, writ petition 85 of 2023 stands dismissed and disposed of.
Obliged. I seek your lordship's indulgence in making a mention regarding item number 3 of part 2. My lord, leading counsel for respondent number 1 has some personal difficulties, so if this matter may be listed in the next week.
Mr. L.H. Liantrima, is it?
Yes.
Have you taken the consent?
Yes, my lord.
Okay, both of you are here. Mention is made on behalf of Mr. L.H. Liantrima, learned senior counsel for the respondent number 1 for adjournment of the matter, which is not objected by Ms. Bilal Ramnemi, learned counsel for the appellant. In view of the above, list
Next week, my lord.
If it's possible, my lord, after ensuing vacation.
after the vacations. Yes.
Obliged.
For motion, item number 2.
May I seek lordship for withdrawal of my petition with the liberty to file afresh?
Why? What happened?
Lordship, the reason is that we have some formal defects in regards to
Oh,
one of the annexers, which is annexer number 3.
so you want to withdraw instead? Okay, good.
Yes.
Miss, is your name there in the cause list?
Yes,
Miss,
Lordship.
Miss, what's your name?
Narin Thari.
Lalwin Thari, learned counsel for the petitioner, has prayed for withdrawal of the instant writ petition with a permission to file afresh, since there are some mistakes made in the writ petition. Praise aloud. WPC number 68 of 2025 stands dismissed, stands disposed of on withdrawal with the permission to file afresh if so advised.
Deeply
Yes.
obliged.
Item 3.
Disposed of, okay, not dismissed. Yes.
May it please your lordship. The matter before your lordship in this petition is a prayer for compassionate allowance in accordance with Rule 41 of the CS Suspension Rules 2021. May I proceed with the brief case of fact? I was inducted in the Indian Reserve Battalion in Mizoram in 1994. Thereafter, I have been in continuous service for about 12 years. In the year 2006, I was assigned to undergo pre-induction training course in CIZW Pairengte in Mizoram for further deployment in the operation of Naxalite in the state of Chhattisgarh. However, the training was happened in the month of August. During training, my wife was hospitalized, and though I have submitted a written application to my superior, my application was not acknowledged and it was not even registered. So therefore, because of my concern about my wife and my 7-month-old baby, I
Okay, anyway,
Left,
so you were not giving compassionate what?
compassionate allowance.
Allowance.
Yeah.
Then you had submitted a representation
Yes, my lord.
which was declined.
Yes, my lord. The grounds of the
So your writ petition is against this order dated 0402, 2025, is it?
no, my lord.
Declining.
This is the
Declining your this thing, prayer for compassionate allowance, isn't it?
yes, my lord. I have submitted my personal representation on the 25th.
Which was not this thing, which was
Not-
declined,
yeah,
isn't
it was
it?
declined. Yes, my lord.
So you have come to this court aggrieved by that.
Yes, my lord.
But here it says that the petitioner again submitted representation for reconsideration.
Yes, my lord.
Now, this reconsideration submitted on 2802, 2025,
Yes.
is it,
It's not
okay, it's not in the
It's
form
not.
of an appeal, it is just a reconsideration?
Yes, my lord.
Is it?
Yeah. The ground of the decline was compassionate allowance cannot be granted.
So you're waiting for the result of your representation
Yes, my lord.
submitted for reconsideration on 2802, 2025,
Yes,
isn't
my
it?
lord.
So can the present writ petition be disposed of by informing the concerned authority to dispose of your representation submitted on 2802, 2025 expeditiously, maybe within, when was this? February. So maybe within 3 weeks, if this representation submitted by you is disposed of, and then thereafter, if you are unhappy, we can still consider. Where's the representation made by you on 2802, 2025 for reconsideration? That's it, is in page
36, my lord.
36.
Annexus 16. And the
Because you're still waiting for the result of your representation,
I-
isn't it?
yes, my lord.
36, wait, let's see how have you filed.
And the
English is in
English
37.
is in 37.
Yes. Just read that, page 37, the operator this thing, in reference to the
In
reply.
ref-
Yes.
in reference to the reply received pursuant to the letter submitted by me concerning compassionate allowance, wherein you stated that according to CSS Pension Rules 1972, Rule 41, Sub Rules 1 and 2, since I have not made a claim within the prescribed limitation of 6 months, no further proceedings can lie in respect of the said claim in an incorrect ground. That the main point of Rule 41 of the Pension Rules 1972 being that government servant having service before the year 1972, if dismissed, shall make a claim within a period of 6 months from the date of implementation of these Pension Rules 1972, wherein the reply furnished by you is based on incorrect interpretation of law. With regards to compassionate allowance, which I have mentioned, there are numerous Supreme Court and High Court judgments in India to be read and seen, wherein in some cases a claim was made after a period of 6 months, wherein a claim was made after a period of 10 years, which was granted. I can therefore provide you the said court judgment if so required by your respective office.
Okay, so in your reconsideration, you have pointed out the grounds why
Yes.
your rejection order should be reconsidered. Okay. Now, these same grounds are the grounds for which you have approached this court for being aggrieved by the first representation made by you rejecting the
Yes.
representation. Same grounds, isn't
Yes, my
it?
lord. Yes.
So, what you can, the instant writ petition can be disposed of by passing an order that this representation filed by you dated What was the date you said? Dated. Where's the date in your representation? No date is mentioned here. Page
My lord, in
37?
the 28 to 25 in the translation, I have missed out the date.
Okay, that is missed out, but
Yeah.
in the vernacular, the
yeah.
date is given, yes. So this thing, let them dispose of this matter first. And we'll pass an order that it should be disposed of within 3 weeks.
All right.
And in the meantime, you have the liberty to furnish a copy of the judgments,
All right.
which you've mentioned, numerous Supreme Court judgments. In your writ petition, have you cited those judgments?
No, my lord.
No.
I will provide
So it's in the air? No,
in,
you should
in the
say.
middle.
Because anyway, so we will dispose of the instant writ petition at the motion stage by saying that this representation made by you should be disposed of, okay, within 3 weeks. And in the meantime, you have the liberty to furnish the judgments which you wish to rely on in your representation to the
Yes, ma'am.
concerned authorities.
Yes, ma'am.
Okay. So I'll pass the full order later. Because the facts of the case will have to be highlighted here and there. It may be a slightly long order, but the operative part will be like that. Okay. And then notice will be issued, notice of motion, and then we refer the matter. Okay, so you furnish a copy of the writ petition anyways, but it is disposed of in the following manner, okay, within 3 weeks. I'll pass the full order later.
Obliged, ma'am.
Item 4.
Lordship, this is a writ petition filed under 226. However, Lordship, this is somehow a covered matter, as this Honorable Court
Not fully
already
covered, somewhat only. So some different.
not page number 53, Lordship.
53. What is the matter about?
Yes, Lordship, this is a matter about that the Deputy Commissioner, on the strength of his position as a
Oh,
District Revenue Officer.
yes. You're saying that he is not their competent authority.
Lordship,
So we had issued notice.
Notice
I think.
already, Lordship.
So we'll issue notice here also.
Lordship.
You had prayed for time in the previous date to get instructions regarding that, isn't it?
Yes, Your Lord.
When was that matter? So we will list this along with that writ
Yes.
petition. What is the other writ petition?
63 of
Okay.
25.
Heard Mr. T. Lalunsiyama, learned counsel for the petitioner, who has filed the instant writ petition under Article 226 of the Constitution of India for issuance of the appropriate writ to the respondents, being aggrieved with the show cause notice dated 23rd May 2025, issued against the petitioners by respondent number 4, that is the Deputy Commissioner, Aizawl District, Aizawl, regarding the encroachment of the Industrial Growth Center, Luangwal, Aizawl by the petitioners. The case of the petitioner is that the Deputy Commissioner has no authority to issue the impugned show cause notice under the, what act was it?
Mizoram
Let's see,
Prevention
under
of-
the, under.
Government and Encroachment Act.
Wait.
Lordship, page number 46.
46, under the Mizoram, within brackets, Prevention of Government Land Encroachment, close bracket, Act, 2001. Full stop. Notice of motion be issued to the Respondents, Ms. Lalnun Louis, learned government advocate, accepts notice on behalf of the state respondents. Requisite copy of the writ petition to be duly furnished to the learned government advocate. No private risk, nothing, isn't it?
No private.
A list after 3 weeks. It is also submitted that there is a similar matter pending, which is registered as WPC number
63.
63 of 2025, and that both the matters may be clubbed together. Considering, accordingly, the said WPC number 60 something is to be clubbed along with the instant writ petition. List these matters after 3 weeks.
Lordship, one more thing. In the previous case, the stay order was interim stay order was granted,
Okay.
and then that stay order may be applicable in this case,
Okay.
Lordship.
Meanwhile, the operation of the impugned order dated, the same date, okay, is to
23rd
be
May.
stayed till the next date of listing. Yes.
Much obliged, Lordship.
For admission, item 5.
May please, Your Lordship. My Lord, in this case, in the last court order, the
Yes.
learned counsel for the state was supposed to obtain clarification on section 97 of the Mizoram Land Revenue Act of 2013.
Yes, my lord, and I have received the same. I am directed to clarify that section 93 referred to is section 97 of the Mizoram Land Revenue Act 2013 is a typographical mistake, and it should be read as section 96, which is related to exclusive jurisdiction of revenue courts and bar of jurisdiction of civil courts.
Okay. So in that case,
It somehow clarifies the confusion,
in that case, maybe there is a ground to review.
my Lord.
Yes, Mr. This.
Your Lordship, I have just received.
No,
I have just
I
received
think,
the
I
clarification.
think this
We
should
may
be,
fix
this should
someday.
be, okay, copy will be given to both of you, then we will consider the review, this thing, petition after that. Because then we have to see the judgment, because I think in the judgment also, this point was pointed out.
My Lord.
Okay, then we'll have to see, isn't it? Whether there is a ground, we'll have to look, Mr. Lalfa Komo, learned counsel for the petitioner is present, along with Mr. T. Lalnon Siama, learned counsel for the private respondent, and Ms. Caroline K. Lallumoipui, learned government advocate for the state respondents. The learned government advocate has submitted a letter dated 20 June 2025, which is in response to the query made by this court on 02/05/2025 for the state respondents to clarify whether the words within inverted commas, section 93, close inverted, mentioned in section 97 of the Mizoram Land Revenue Act, 2013, should be read as section 96, full stop. As per the clarification made by the state respondents, it is stated that, okay, this within inverted commas, the said letter dated 20 June 2025 is to be marked as X and made a part of the record. Copy of the said letter dated 28 June 2025 is to be furnished to the learned counsel, to the learned counsels for the petitioner and the private respondent. Then list the matter. Yes,
Anytime next week, my Lord.
after the vacation. Okay. What, after the vacation?
There is
Or
some,
before?
there is some
Okay.
urgency because
Yes.
this has a very rippling effect in all the other cases.
Okay, list
in
the
the district.
matter on, when do you want it? Next week? When do you want it? Any date, when all of you are available?
3rd, my lord, Thursday.
Okay, list the matter on 3rd, 7, 2025. Yes.
Deeply obliged.
I'd like to answer.
Item 6.
My lord, in this matter, I have been requested by Mr. Larokung Apauto, who is appearing for the respondent number 1, to pray for an adjournment on the ground that he has gone out of station.
Yes, then what do we do? You have to adjourn?
No objection, my lord.
Miss B. Lalram Nemi, learned counsel for the petitioner is present, while mention is made on behalf of Mr. Lalrokung Apautu, learned counsel for respondent number 1, for adjournment of the matter, since the learned counsel is said to be out of station due to some, is said to be out of station, full stop. Okay. Then,
Mr. Michael Patrol, on behalf of my senior, Mr. Johnny, for respondent
yes,
number 2.
Mr. Michael Patel appears on behalf of his senior, Mr. Johnny L. Tochong, learned counsel for respondent number 2, and Ms. Vani Siami, learned government advocate for the state respondents number 3 are present. Okay. In view of the submission made on behalf of on behalf of the learned counsel for respondent number 1, which is not objected by the other counsels, list the matter after the ensuing vacation.
I'm obliged.
Item 7.
My lord, in this matter, I have been requested by Emmanuel L. Chazola, one of the counsel for the petitioner. The leading counsel, Mr. Monojit Biswa, could not turn up today, so they asked him to pray for an adjournment.
Okay, wait, let me see. 2 weeks. This is for admission hearing. Pleadings complete or what?
Yes,
Pleadings are complete.
yes, my lord. Matter may be taken up on
After the
25th.
vacation.
Yes, they pray for time fix.
Mention is made on behalf of Mr.
Emmanuel L. Chazola.
Emmanuel Lal Thazwala, learned counsel for the petitioner, for adjournment of the matter, which is not objected by Ms. Malswamy, Mrs. Malswamy, H. Malswamy, learned counsel for respondents number
5 to 7.
5 to 7, and Ms. Lal Nundloi, learned government advocate for respondents number
1 to 4, Your
1
Lordship.
to 4. In view of the above, less after the ensuing.
My lord, kindly
Oh.
be fixed
On,
on 25th
on
July.
25, 7, 2025. Yes.
Obliged.
Item 8.
My lord, in this matter, notice was issued on 23/5, and this is the second time this matter is listed. However, my lord, the petitioner has instructed me to withdraw this writ petition, my
Oh,
lord,
why?
because he have informed me that he has some personal difficulty
Okay.
in pursuing the matter.
Yes.
If liberty may be granted, my lord.
Oh, okay. But Mr. C. Tlantiang Lima, learned counsel for the petitioner, who submits that he has been instructed to withdraw the instant writ petition since the petitioner does not wish to pursue the matter at this stage, and pray that he may be given he may be given the liberty to file afresh. Full stop. In view of the above submission, the instant writ petition number 52 of 2025 stands disposed of on withdrawal with the permission to file afresh if so advised.
Obliged.
For orders, item 9.
Your Lordship, we did not find the respondent at first, but then this morning we found out that he is in central jail serving a conviction in some other POCSO matter. So if I may be granted another 1 week time for serving notice. Deeply obliged.
May it please your Lordship. In terms of the the court's order, we have taken step on 14/5/2025. However, the notice has returned unserved with a note saying insufficient address. So, I believe the respondent in the meantime had changed her address.
So you get the correct address.
If I may be allowed to serve notice by way of dusty, my lord, because after all, she is the stepmother of the appellant.
Okay. Heard Mr. Zoram Chana, learned counsel for the applicant, who submits that since the office note dated 23/05/2025 indicates that notice could not be served to the respondent due to insufficient address, he may be allowed to serve notice to the respondent through dusty mode. Praise the Lord. The learned counsel for the applicant / appellant is to serve notice upon the sole respondent, is it?
Yes,
Through
madam.
dusty mode, and if affidavit to the effect is to be duly furnished. List after
2 weeks, madam.
2 weeks.
Yes, madam.
Okay, list after 2 weeks.
Obliged, my lord.
Item 11.
Who is for the, oh, we have to issue notice, is it? Have we issued notice? No. Who is appearing in this case?
I am appearing in this case, Your Lordship.
Okay, so an IA has been filed praying for substitution, is it?
Yes, my lord.
Of her late husband, so and so,
Yeah.
on the demise. So we'll allow
Your Lordship,
say-
I have some
some reservation.
submission to make.
Okay, we'll issue notice, file a written objection if you have any. Okay.
Your Lordship, this has to be, I believe that it cannot be, the petition, the application cannot be appreciated as it is. It's not maintainable as it is, because this is filed under 151 of
151.
CPC. Rather, it should be CPC order 22, Your Lordship. And Your Lordship,
151 it has filed, huh? You have already have a copy or what? Yes, okay.
yes, I am served a copy. And Your Lordship, this
So
is
file a written
fi-
objection. File a
okay,
written objection,
all right,
we'll
all
hear
right.
the matter. Because the first time it's coming up, though, copy was already served to you beforehand, isn't it?
Yes.
Yes, heard Miss Jacinta, so and so, learned counsel for the applicant / petitioner, who has filed the instant application under section 151 of CPC for substitution of the petitioner, Mr. Lalthona, is it late? In WPC number 130/2023 by his wife, Srimati Lalrun Liani, resident of Colosseum, Mizoram, in the said writ petition number, what was it? Yes, I just mentioned writ petition number 130/2023. Good stuff. Notice be issued to the respondents. Miss Mary Elkiante accepts notice on behalf of the state respondents. Any other?
And 3 to 4 also accept the notice on the same.
3 to 4 are who?
3 and 4 are the central government.
Okay. Notice be duly served to the respondents number 3 and 4 through registered post with AD.
Already accepted the notice.
Where's the letter? Through registered post.
The receipt is enclosed in my petition, my lord.
Through registered post. Okay, issue notice to the state respondents. No, issue notice to the respondents. Then Miss Mary so-and-so accepts notice on behalf of the state respondents. It is also, see, you serving without a court's order, it's a little bit difficult to accept. Notice also should be also served to the respondents number
3 and 4.
3 and 4. Through registered post with AD. Returnable within 3 weeks. Requisite copies of the said writ petition to be duly furnished to the learned counsels for the respondents, if not already done. Yes. List after 3 weeks.
Yes, my lord. Much obliged.
If I may seek your lordship's indulgence, in mentioning item 13 of part 2, the counsel for the appellant is not present today, so I don't think it can be taken up today.
Have we finished part 1? Okay. See, all those mentions, you should do it before we dig up,
Yes.
but luckily part 1 has been completed now in
Yes.
part 2. Yes.
I was thinking we are going to have it today, but since the counsel for the appellant is not present,
Which item?
item 13. Yeah,
Item 10.
13.
13. Mention was already made yesterday,
Huh?
it appears.
Oh, I'll not mention Dharma. Oh,
Okay, a date was already fixed. Please
yes,
find
madam.
out.
I'm not informed. I apologize, madam.
13th.
Okay.
Date is fixed. Find out from the registry
Yes,
which
madam.
date.
Yes, madam.
Yes.
Yeah, at the outset, Your Lordship, I would like to tender my apology for making a mention out of turn. This item 9 was fixed for hearing today. Although both the parties are here and present and ready, my understanding is that item 6 is going to be taken up today and it might take some time. That's what I've been informed.
It might not, it's only at 11. We can do it later also. So this thing now, but item number 9, this is an IA. How is it fixed for hearing?
No, there's a appeal.
IA has been disposed of?
IA is clubbed with the main appeal. Maybe it's reflected in the next page, the appeal.
So IA has been disposed of?
No, my lord.
Then?
It was supposed to be taken up with the main case at the time of hearing. Because it will have a direct bearing on the main case.
Okay. Anyways, we'll see. So both the councils are present?
My lord.
For which item?
9.
Item number 9, ma'am.
9.
Part 2.
Then which is the other one? You're for item number?
9, ma'am. I'm for
9.
the respondent number in item number.
Okay, then which is the other item fixed for today?
6. The parties are
6.
ready and they said they might take some time.
So we can do it in the afternoon, unless both of you want to pray for adjournment. Not because one item, only one item a day, it's not the way it goes.
Understood, my lord. If
Still
possible,
four.
if we can take it up on Tuesday, my lord. Monday being holiday.
Okay. On the prayer made by the learned counsels for both the parties, list, what's Tuesday's date?
1st of July.
On 1/7/2020.
Deeply obliged.
Yes.
Hearing list, item 6.
Yes.
May it please your lordship. My lord, the writ petition is against the impugned penalty passed against me after disciplinary proceeding had been conducted. Major penalty was given to me, my lord. I am the one of the employees of the Mizoram Rural Bank. And the major penalty given to me was reduction to 2 stages lowering time scale of pay for 2 years, and which has the cumulative effect. Although the impugned order was passed on 18/12/2021, that specified period of 2 years had already expired. However, my lord, it has the future effect. So still, I have the locus, even if the case is not yet disposed of today. So I preferred the appeal, my lord. The departmental appeal was also rejected. So that's why I'm approaching this honorable court. And my lord, the proceeding starts with the...
Yes. You
Yes.
can vote, please.
I may take your lordship to page 28 of the writ petition, my lord. It starts with the notice. I may read your lordship so that the facts will be acknowledged from here. His letter was addressed to me. I'll start from Madam. Irregularities, no gross negligence, misappropriation of funds, head office, BGL account number so-and-so, and other customer accounts explanation. It is observed that the under-noted serious irregularities were committed by you in different accounts when you were working as the manager at head office. On 14/1/2019, you have transferred rupees 12 crores, 12 lakhs 23,041.61
Increase the AC.
paise from HO provision, others account number so and so, to 25 different IDB. This is intra bank deposit, my lord. IDB account of branches and or HO as
Make it
reversal
19 or
of funds.
something. 19 or 17. Let's see. Yes.
As reversal of funds for reconciliation which were transferred to the provision or other account on 31/3/2018, out of which you have transferred an amount of rupees 63,63,778.41 paise to MR Interbank Deposit Saiha, account number so and so, of Tuipang branch, though the amount was not transferred to provision others account number so and so earlier on 31/3/2018, and subsequently misappropriated the amount in different accounts. Number 2, it is therefore clear that you have negligent and grossly violated the bank's extant instructions with malified intention, and by your above acts, bank has exposed a huge pecuniary loss. Number 3, please therefore submit your explanation within 7 days from the date of receipt of this letter as to why you have done such negligence in your duties and why disciplinary proceedings will not be initiated against you, failing which the bank will proceed against you as deemed fit. In the meantime, please acknowledge the receipt of this letter under your full signature with date on the duplicate copy. Chairman and Disciplinary Authority. The letter was issued by him. My lord, why I have read out this letter is that it is important so that to acknowledge the facts of the case, and I had replied this letter. The retyped copy will be more easier to read, my lord. Page 32. This is my reply letter.
Yes.
I'll start from the para one, your lordship, first para. I am in receipt of your captioned letter, duly received and acknowledged by me on 17th December 2020. I am deeply distraught that a trusted colleague had taken advantage of the mutual trust built over years of working for our beloved bank. It is deeply regrettable that the abuse of my trust has resulted in several unwanted consequences, both for the bank and myself. From September 2018 onwards, there was a big push to eliminate all unreconciled entries in transactions, especially branch clearing general accounts and intra-bank deposit IDB accounts. An office order number 12 dated 7/9/2018 was issued where Mr. Zhou Sangpuya was put in charge of resolving the unreconciled transactions under the supervision of senior manager accounts and the general manager. I was one of the incumbent officers in the head office at that time. I had read and acknowledged the said office order by putting my initial, it should be initial, my lord, initial on it. Copy of the said office order is enclosed for your kind reference. On that fateful day of 14th January 2019, around 4 p.m. in the afternoon, even though I was an officer in charge of fixed assets, etc., I was requested by Mr. Zhou Sangpuya to authorize a trickle feed transaction totaling rupees 12 crores, 12 lakhs, 23,041 and 60 paisa for reconciliation of several accounts with head office BGL. Since I was the only officer available at that particular time, I asked Mr. Zhou Sangpuya if everything was in order and he replied affirmatively. After taking a quick glance at the transactions and finding that the credit and debit transactions tallied, I had authorized the transaction for the sake of the smooth functioning of the reconciliation works. Since management had put its implicit faith in his ability to perform reconciliation duties, I had no inkling of the sinister intent of my colleague hiding a fraudulent transaction amidst authentic entries. So unknowingly, because of the trust placed on Mr. Zhou Sangpuya by me as well as him, being given responsibility for the reconciliation exercise and his senior manager accounts was out of station on that day, I ended up authorizing the transaction which contained a fraudulent entry cleverly hidden amongst authentic ones. An affidavit made by Zhou Sangpuya before the Notary Public on 21st December 2020 is also enclosed for your kind perusal. I deeply and truly regret that my action has caused grief to my colleagues and the bank. I, however, deny taking part or acting in connivance with Mr. Zhou Sangpuya on any level or deriving any benefits from these fraudulent actions of Mr. Zhou Sangpuya to this day. It is my humble prayer and appeal to the appropriate authority to kindly take a lenient view and not to impose any punishment on me. So, my lord, the next page, page 34, is the office order wherein Mr. Zhou Sangpuya, manager, was entrusted to do the reconciling entries work in the head office. And the next page, 36 is the retyped copy, my lord. This is the affidavit, my lord. May I quickly read out this affidavit of Mr. Zhou Sangpuya? He says like this, from para 1, I'll read, that I am bona fide citizen of India, belonging to Scheduled Tribe Community of Mizo, that I was previously working as manager, Accounts Department ID 323, Scale 2, Mizoram Rural Bank, Head Office, Aizol, Azarkot, Aizol, that on 14/1/2019, I had raised a request for authorization or passing of a transaction of transfer of rupees so-and-so from head office, provision others account numbers so-and-so to 25 different IDB account of branches or HO as a reversal of funds for reconciliation, which were transferred to the provision or other account on 31/3/2018. I also transferred an amount of rupees 63,63,778 and 41 paisa to MR Interbank Deposit account number so-and-so of Tuipang branch, though the amount was not transferred to provision others account number so-and-so earlier on 31/3/2018 and subsequently misappropriated the amount in different accounts. That I was fully aware that P. Judil Lalomzwali, she is the present petitioner, my lord, ID number so-and-so scale 2 was working as a manager in charge fixed assets at that time. I requested her to authorize the transaction as she was the only passing official available at that time. That P. Judila Lomzoli, without raising any suspicions, duly approved my transaction request and made necessary signature on the voucher. That I do hereby declare that I have planned and made the misappropriation of funds and that P. Judila Lomzoli is in no way involved nor responsible for the said misappropriation. That I have made this affidavit in sound mind and without any force or coercion from any corner. I'll stop here, my lord.
But what does it mean here? Just explain
My lord.
para 3. authorization
Yes.
to transfer so much from the head office to other different IBD accounts, branches.
Yes.
Such as reversal of funds. What does all this mean for
Your Lordship,
reconciliation?
to my understanding, it happened usually in the, particularly in MRB, Mizoram Rural Bank, that when some account statements need to be reconciled. For an example, some transactions are there, and those transactions there are some mismatching amount. So, but in fact, although the amount is not actually misappropriated, even if it's not misappropriated, so some mismatching of the amount could happen. So, in order to clarify and to reconcile all these things, some officers had been generally appointed to do the reconciliation work, so that it could be.
So what loss will the bank
compromised.
face if this reconciliation is done?
That is one of my grounds also, my lord. No loss had been, no pecuniary loss at all. So it is within the bank itself, reconciliation work. The name itself is also reconciliation work.
No. Okay, so no actual loss. This is for reconciliation.
Yes, no actual
of
loss.
the mismatching, whatever.
Yes,
Okay.
it has to be
yes.
compromised. So, my lord, what it says, Paratri itself, what it says is that in order to do such kind of works like to access some kind of accounts, then it is generally, it happens that one of the officers, other officers' authority is sometimes needed. So that is why the present petitioner also, gave the authorization in the transaction, my lord, as per the request of Mr. Zosang Puya. So page 37, I will not read out, my lord. This is the charge sheet. Thereafter, I was served with the charge sheet. The contents of this is same with similar to what I have read out, my lord. That the notice which I have read out initially. So I will not read this. And articles, page 39 is the articles of charge leveled against me. And this is also the same thing. I will not reiterate, my lord. And page 40 is the statement of imputation. The allegation is same. There is nothing added here. And my lord, page 41 is my written statement of defense. This is also more or less the same with that my reply to the explanation letter. So I'll leave this, my lord.
So how have you explained just page 39?
My lord.
Okay. Article of charge, page 39. Here it says, for misappropriation, embezzlement.
Yes.
How have you explained
My
this
lord,
part?
in that regard,
the said amount is 63 crores, 63 lakhs.
It is not misappropriated. I have explained in that
Okay,
way.
where have you explained that? In
Your
your,
Lordship, may I-
this thing, reply,
Yes.
written statement of
If I'm
defense,
not-
which para?
Yes, Your Lordship.
Now, I just want to know whether that said amount, 63 crores, is still revolving within the different branches of the bank,
Yes, my
or
lord.
it's been taken out and pocketed by some individual, whether the petitioner or this person mentioned. That's all. I'm just curious.
Yes, my lord, may I read out this page 41? So I think, or in some other. Okay. I'll read from serial number 1. A so-cause notice was issued to me by letter wide number so-and-so, in which I was noticed to submit my explanation clarifying the allegations given in the letter. I made the reply without delay by a letter dated so-and-so, in which all the facts and circumstances constituting the allegations were spelled out, and hence there have been no grounds to proceed with the instant proceedings. As per the article of charge, it was alleged that during my tenure as manager, fixed assets of Mizoram Rural Bank Head Office acted in the manner which was prejudicial to bank's interest. I was alleged to commit gross negligence and the reliction of duty with malefied intention, and on 14/2/2019, I was alleged to authorize and transfer rupees 63,63,778 and 441.41 from head office provision other account number so and so to account number so and so to MR Interbank Deposit Saiha.
So it was,
Yes.
that was transferred to MR Interbank Deposit
Deposit
Saiha.
Saiha. This
So
is-
it depends, belongs to the same bank,
Same
isn't
bank,
it?
my lord,
But
it
a
is.
different branch.
Exactly.
Then what happened after that to this money?
Then, my lord, I'll read, yes. For misappropriation and embezzlement, due to such alleged misconduct, you made a charge against me for commission of gross misconduct in terms of regulations numbers 18 and 20 of the Mizoram Rural Bank Officers Employee Service Regulations 2010. This is with regard to, my lord, dereliction in duty and commission of gross misconduct. This rule, particular rule 18 and 20. Para 3. As already given in my letter dated 23/12/2020, which was a reply to the so-called notice dated 15/12/2020, it is pertinent to reiterate that from September 2018 onwards, there was a big push to eliminate all unreconciled entries in transactions, especially branch clearing general accounts and intra-bank deposit IDB accounts. An office order number 12 dated 7/9/2018 was issued, where Mr. Zhou Puya was put in charge of resolving the unreconciled transactions under the supervision of senior manager accounts and general manager. I was one of the incumbent officers in the head office at that time. I had read and acknowledged the said office order by putting my initial on it. On that date, that is 14th January 2019 at 4 p.m., I was requested by Mr. Zhou Sampuya to authorize a trickle feed transaction totaling rupees 12 crores so and so for reconciliation of several accounts with head office BGL, since I was the only officer available at that particular time. I asked Mr. Zhou Sampuya as to whether everything was in order, which was replied affirmatively. After taking a quick glance at the transactions and finding that the credit and debit transactions tallied, I had authorized the transaction for the sake of smooth functioning of the duties. I had done nothing wrong in this said authorization as such. Mr. Zhou Sampuya also specifically stated facts constituting said transactions by the affidavit dated 21/12/2020. Such being the situation, I would like to state that the charge leveled against me is not maintainable. Regulation 18, number 18 runs as liability to abide by the regulations and orders. Every officer or employee shall conform to and abide by these regulations and shall also observe, comply with, and obey all orders and directions which may from time to time be given to him by any person or persons under whose jurisdiction, superintendence, or control he may for the time being be posted. From the statements above, for a charge under regulation number 18, there must be, number 1, an act or omission against any provisions of the regulation. Number 2, negligence of orders and directions from superior. The charge sheet must contain the relevant regulations which constituted an act or omission of the charge officer. Further, the charge sheet must also clearly specify an orders and directions of superior officers or authority which I have been deemed to contravene. Without specifying the aforesaid requirement in the charge sheet, I could not be simply charged under regulation number 18. The said authorization without any modified intention would not amount to valid charge under the aforesaid regulation number 18. Regulation number 20 also runs obligation to promote the bank's interests. Every officer or employee shall serve the bank honestly and faithfully and shall use his utmost endeavor to promote the interests of the bank and shall show courtesy and attention in all transactions and dealings with officers of government, the bank's constituents and customers. Ingredients of this regulation may be summarized as every officer or employee, number 1, shall serve the bank honestly and faithfully. Number 2, shall promote bank's interest in his utmost endeavor. Number 3, shall show courtesy and attention in all transactions and dealing with officers of government, bank's constituents and customers. Firstly, I have served for the bank honestly and faithfully since my joining to this day with no adverse incidents against my name. The second ingredient requires promotion of bank interest in the level best effort or utmost endeavor. Since I joined the bank, I have served for promotion of the bank's interest in my level best effort, and as such the same may also be found not liable against me. The third ingredient is also not found liable against me. Since I joined the bank, I have shown courtesy in my level best effort towards my fellows, customers, other officers, etc. I have also paid my level best attention in all transactions and committed no fault till date. To this day, I have never involved myself in any unscrupulous activity in any connection with the bank which would have resulted in deriving any manner of benefit for myself. The allegation of malified intent is therefore unfounded and without substance. Further, I would also like to mention herein that as per the charge sheet, there was a huge pecuniary loss suffered by the bank due to my alleged misconduct. However, the amount and other details of loss allegedly suffered by the bank is nowhere mentioned in the charge sheet, which itself is technically unsound. Hence, the charge sheet is not maintainable in its present form and style. Such being the situations, apart from non-maintainability of the charge sheet, it is my humble submission that I contravene neither regulation number 18 nor 20 of the Mizoram Rural Bank Officers and Employees Service Regulations 2010. I am further to state that I abide by the regulations and orders, regulation number 18, and have also rendered my level best effort in promoting bank's interest to this day. Further, as mandated by regulation number 20, I have always shown courtesy and attention in all transactions and dealing with other officers, etc. Hence, I have denied the article of charge imputation made against me and humbly request removal of the charges leveled against me. If not, it is my humble prayer that I may be heard in person to prove my innocence, and also pray to kindly allow me to engage advocate as provided under regulation 44 of the so-and-so regulation 2010. So, my lord, what basically I have stated here is that in my reply, I am reply on from the angle of by considering Rule 18 and 20, nothing was contravened by me with regard to Rule 18 and 20. And one important point which I had raised is also, which is to the effect that, my lord, while the bank is, the disciplinary authority is stating that pecuniary loss happened, but it was nowhere how that pecuniary loss happened and in which kind of account it had happened. Nothing was mentioned because everything was done within the bank itself, your lordship. This is the mismatching and non-compromise of the amount only. So that is what I had raised in my and thereafter, my lord, the proceeding was carried on, and page 46 is the
Hearing, is it?
yes, your lordship, and thereafter page 50 is the relevant one, your lordship. That is, the inquiry officer had didn't find any incriminating evidence against me.
Did not find.
Yes, did not find. Okay. Not proved, my lord. But disciplinary authority, there is the chairman, didn't
Where does it
accept
say
it.
not proved?
Not proved, your lordship. Yes, page 50. my
Okay,
lord.
okay, yes, page 50, not
Yes,
proved.
yes,
I
the
do
first-
not agree.
Yes, the second
Okay.
column, inquiry officer's finding is not proof.
Ah,
And the third column, disciplinary authorities comments, it will be relevant. I'll read out this, your lordship.
yes.
I don't agree with the findings of the inquiry officer. Srimati Judil Lomzoli, the CSO has admitted that she has authorized the fraudulent transaction, and the evidences available on record also proved the same. CSO has not been entrusted with the work of account section according to the referred office order related to allocation of tasks to Mr. Zosampuya. At the material time, CSO was dealing with fixed assets under CM, PNOA. Still, she has authorized the fraudulent transaction leading to pecuniary loss to the bank. From her submission, it is evident that she has not observed due diligence and due attention while authorizing the transactions. Performing the transactions without understanding or verifying was simply her negligence and dereliction of duty, for which bank suffered huge pecuniary loss. And it was against the interests of the bank. Other way, by doing that, CSO assisted Mr. Zosampu to misappropriate the funds. Hence, I treated the allegation as proof. Here also, nothing was mentioned how that alleged pecuniary loss happened, my lord. From which account and how it happened, nothing was mentioned. This, the disciplinary authorities simply said that he did not agree. So, your lordship, thereafter, page 51, my lord, para number 2 says that you may submit your written statement of defense within 7 days from the date of receipt of this letter. Please note that if you fail to submit your written statement of defense within the stipulated period, it will be presumed that you have nothing to state in your defense, and in such an eventuality, the bank will proceed as deemed fit without waiting further in the matter. Why I'm reading out this is that, my lord, my contention, further contention will be no opportunity of being heard. Personal hearing should have been conducted. That is what the law says. I'll rely upon the judgments, your lordship. So nothing happened. I was asked only to submit my written statement of defense. And yes, accordingly, I had submitted. That is page 52. And these are the somehow reiteration of what I have just read out, my lord. So I'll not come to this in detail. And
Written statement given, then?
yes, then this is the proposed penalty, page 54. I'll not read out this. Page para 2, I'll come directly to the relevant portion. It says that accordingly, I, being the appointing authority and chairman, propose to impose on the following penalty. 39.1b, major penalty. Reduction to 2 stages lower in time scale of pay for a period of 2 years. The officers shall not earn increments of pay during the period of such reduction, and on expiry of such period, the reduction shall have the effect of postponing the future increments of our pay. So in this regard, I was again asked to, so cause notice was given to reply my so cause reply, to make my so cause reply, my lord. So I submitted my so cause reply at page 56. I'll not read, my lord, this one. And thereafter, this is the page 57 is the letter which was served to me. This is the impugned order, my lord. And I was also intimated that if I want to file this, I desire to make an appeal, then I should do it within 45 days, so and so. And page 61 is the relevant portion. This is the penalty, handwritten one, my lord. The handwritten one towards the bottom of the page. Page 61.
Yes.
This is the penalty given to me. The same thing, my lord, I'll not read out. Reduction to 2 stages lower in time scale of pay.
Yes.
And with the future effect. And then I filed my departmental appeal, your lordship. This is page 62. I raised several grounds which are similar to what I had explained already before this, during the course of disciplinary proceeding. So I don't think it will be required to read out, my lord. And thereafter, it was rejected at page 68. Page 68, my lord, I will read out this. With reference to the above subject, I have to inform you that your appeal against disciplinary proceedings final order has been placed before 219th meeting of the Board of Directors of the Mizoram Rural Bank held on 18th February 2022. In this connection, we have to inform you that the board's decision in this regard, which is self-explicit as per below, the board being the appellate authority have carefully gone through the imputations of misconduct, findings of inquiry authority along with the comments of disciplinary authority, CSO submission and other related papers, documents, resolved to uphold the decision of the disciplinary authority. So this is the reason why I approached this honorable court. I am challenging my penalty given to me by this disciplinary authority as well as this departmental appeals rejection order. So the first point, my first ground, as I have already stated, is that, my lord, with regard to the merit of the case, so to say, the allegation itself, there is no pecuniary loss to the bank. And it wasn't specifically mentioned even in the charge sheet or by the comments of the disciplinary authority who rejected, who did not agree with the case IO's inquiry officer's finding. Nothing was mentioned how the alleged pecuniary loss happened.
Disciplinary authority.
Disciplinary authority, yes, my lord. And number two is that I was for the benefits of the bank and for the smooth functioning of the bank in doing execution of the reconciliation work, as per the request made by Mr. Zhou Sampui, my superior officer, I had authorized the trickle transaction only, and that was also accepted by way of an affidavit by my superior officer, my lord. And due to that reason, there was no violation of Regulation 18 and 20 of the Regulation of 2010.
Authorization accepted by a superior officer, is it?
Yes, yes. That my superior officer requested me to authorize because
Where's that?
that page 36, the affidavit, he stated clearly, my lord. Para 4, he said that I was fully aware that P. Judil Lomzoli, page 36, my lord.
Okay, so this Zhou Sangpuya is her superior officer?
Yes, the petitioner's superior officer.
Okay.
So it is, there was no passing official.
So is there any case against Zhou Sangpuya?
Yes, my lord. If I'm not mistaken, I think he does no longer work, but I'm not sure. Action was taken against him.
Okay, he
Not
has
only-
not come up before the court?
Yes. If I'm not
Okay.
mistaken, not only one case, several other cases also there. Yes, this is the Allowance Standing Council also agreed. So this is what he also admitted to that particular fact, my lord.
Okay.
So now, coming to the other point, my second ground is that even the case, the inquiry officer didn't find any incriminating evidence against me. Although this honorable court also knows very well that your lordship, in the disciplinary proceeding, the standard of beyond reasonable doubt cannot be applied because it applies only the preponderance of probability principle also only applies. But despite that, your lordship, there is no incriminating evidence at all. So in that regard, and this is the reason why the inquiry officer did not find any evidence against me, and the charges leveled against me were not proved. But that was denied and not accepted by the disciplinary authority without giving any cogent reasons, your lordship. It was simply rejected by the disciplinary authority. That was why I was given that penalty, impugned penalty to me. So in this regard, your lordship, I may rely upon the Honorable Apex Court's decision, 1999, Volume 7, SCC 739, Para 31. 1999, Volume 7, SCC 739, Para 31.
Para 31, yes.
My lord, I'll read. In view of the above, a delinquent employee has the right of hearing not only during the inquiry proceedings conducted by the inquiry officer into the charges leveled against him, but also at the stage at which those findings are considered by the disciplinary authority, and the latter, namely, the disciplinary authority forms a tentative opinion that it does not agree with the findings recorded by the inquiry officer. If the findings recorded by the inquiry officers are in favor of the delinquent, and it has been held that the charges are not proved, it is all the more necessary to give an opportunity of hearing to the delinquent employee before reversing those findings. The formation of opinion should be tentative and not final. It is at this stage that the delinquent employee should be given an opportunity of hearing after he is informed of the reason on the basis of which the discipline authority has proposed to disagree with the findings of the inquiry officer. This is in consonance with the requirement of Article 3112 of the Constitution, as it provides that a person shall not be dismissed or removed or reduced in rank except after an inquiry in which he has been informed of the charges against him and given a reasonable opportunity of being heard in respect of those charges. So, Your Lordship, so-called notice was given to me, and I had submitted, accordingly submitted. That was also I had read out. But opportunity of being heard, it wasn't given to me, my lord, personally. So while saying this, I may rely upon the High Court of Karnataka's judgment, my lord. With your lordship's permission, I may produce this. It was decided on 25/6/2024. This is, I had downloaded from the website, my lord. I could not find it in the SCC online. Sorry for that. Para 13(1)(3). Why I'm pointing out this is to clarify that what is the meaning of the hearing, my lord. Para 13, page 15(1)(5).
Yes,
At the top of the page, my lord. I may read, your lordship.
yes.
The other judgment which emanates from service jurisprudence, the division bench, considering the State Bank of Mysore regulations, would hold as, apart from that, there is a greater illegality in the procedure followed by disciplinary authority against respondent. Sub-rule A2, so and so, the rule reads, he shall also be given a hearing as regards the nature of the proposed punishment in case any charge is established against him. So this particular sentence hearing is relevant, my lord. This sub-rule envisages something more than more opportunity to be afforded to the respondent. It requires a hearing to be given. The difference between mere opportunity and hearing is explicit. There may be fusion between the two, but there should not be a confusion between the two concepts. Opportunity may be extended to hearing, but hearing cannot be condensed or limited to mere opportunity to file objections or representations. Hearing means ordinarily an opportunity of being heard. That means personal hearing. It is also clear from Rule 19.12e of the rules which provides, however, if the employee concerned requests a hearing regarding the nature of punishment, such a hearing shall be given. Similar word, hearing appears in sub-rule 3 of Rule 6 of so and so, for grant of house size rule so and so came for consideration before this court in so and so Bangalore, to which one of us so and so was a party. While interpreting the said word, it was observed. Sub-rule 3 positively states that the assistant commissioner shall hear the objector and the block development officer. Hearing in the context is personal hearing and not mere opportunity to file objections. If the right to be heard is to be a real right and is worth anything, it must carry with it a right in the person to know the case which is made against him. He must know that what materials have been collected, what evidence has been given, and what statements or statements or reports have been made affecting his rights. He must be given a fair opportunity for correcting or contradicting any relevant statement prejudicial to his view. These principles appear in all these cases.
Okay, so
right?
the matter here is
Yes.
regarding some disciplinary proceeding or something else?
Yes, personal hearing.
Regarding what? In the cited judgment,
This is the discipline proceeding,
this,
my lord.
again, another disciplinary proceeding,
Yes.
is it?
Yes.
Okay.
So why these two citations, why I'm relying upon is that, my lord, if it says that in 1999, volume 7 SCC, it says that para 31 particularly says that if disciplinary authority doesn't accept the finding of the inquiry officer, then before coming into the conclusion, the penalty, opportunity of being heard should be given, my lord, to the delinquent, to the charge officer. But it wasn't done so in the present case. So, and hearing, what does it mean is that I'm relying upon this Honorable High Court of Karnataka, my lord. And my last citation will be 2017 volume 2 SCC.
Yes.
To 2017 volume 2 SCC 308. Para 7, my lord. This is regarding the evidence. I may read, my lord.
Yes.
We have given our anxious consideration to the submissions at the bar. It is true that a writ court is very slow in interfering with the findings of facts recorded by a departmental authority on the basis of evidence available on record. But it is equally true that in a case where the disciplinary authority records a finding that is unsupported by any evidence whatsoever or finding which no reasonable person could have arrived at, the writ court would be justified in not duty bound to examine the matter and grant relief in appropriate cases. The writ court will certainly interfere with disciplinary inquiry or resultant orders passed by the competent authority on that basis if the inquiry itself was vitiated on account of violation of principles of natural justice, as is alleged to be the position in the present case. non-application of mine by inquiry officer or disciplinary authority, non-recording of reasons in support of the conclusion arrived at by them are also grounds on which the writ courts are justified in interfering with the orders of punishment. The High Court has, in the case at hand, found all these infirmities in the order passed by the disciplinary authority and the appellate authority. The respondent's case that the inquiry was conducted without giving a fair and reasonable opportunity for leading evidence in defense has not been effectively rebutted by the appellant. More importantly, the disciplinary authority does not appear to have properly appreciated the evidence nor recorded reasons in support of his conclusion. To add insult to injury, the appellate authority, instead of recording its own reasons and independently appreciating the material on record, simply reproduced the findings of the disciplinary authority. All told, the inquiry officer, the disciplinary authority, and the appellate authority have faltered in the discharge of their duties, resulting in miscarriage of justice. The High Court was, in that view, right in interfering with the orders passed by the disciplinary authority and the appellate authority. So this concerns with the evidences, my lord, to be recorded. Nothing was recorded, my lord. So these are my grounds. And lastly, my lord, but not the least, one thing I would like to point out is that although I haven't found the supporting rulings, but the disciplinary authority imposed penalty against me, upon me. And then I filed a departmental appeal, and it was considered by the board, wherein the chairman and disciplinary authority was also one of the authorities.
Members, board
Yes,
members
yes.
of the appellant. This
Exactly,
thing.
my lord. So that is what I would like to point out. So by thinking of the principles of natural justice, it cannot happen in that way. I have searched
Okay.
the supporting.
Anything in the rule mentioning that the bank has their own disciplinary thing, isn't it?
Yes, my lord. My lord, I may produce this.
So the appellate authority is
the
a board.
Board.
The chairman is not the member, but one of the members of the board is the disciplinary authority.
Yes, he's the disciplinary authority, and he's also the chairman. Being the chairman, he's the head.
Oh, he's
of the
also the chairman
Yes.
of the appellate
board.
authority.
Yes, my lord. There is what?
Then he's looking into his own decision, isn't it?
Yes.
No, the disciplinary authority is also the chairman of the appellate authority.
Yes, because he's the chairman of the board. My lord, because it is very clear from this, I may take a lordship again to page 61. This is the impugned penalty. Here it says, my lord, at the bottom of the page, left side, chairman and disciplinary authority.
So chairman and disciplinary authority, but not chairman. Okay, this is the order passed by the appellate authority. No.
No, my lord, appellate
Then
authority is
how
the
can you simply presume chairman and disciplinary authority, but not chairman of the appellate authority? No.
because the board is headed by the chairman himself, my lord.
But chairman of what?
Chairman of the board, because this last page.
Which
page
board? What
68,
board?
Board of directors of the MRB.
Then you have to find out whether it's the same person or not.
Although, in order to find out, I think the relevant documents will be produced. It may be necessary, my lord, because my documents are limited. I could not have access to all these.
Even through RTI, you can find out. But is your submission this submission? Let's see if it will be denied or not. If it's admitted, it's
Yes.
a different matter.
Yes, the Learned Standing Council. What will he say? I don't know,
We'll
my
have
lord.
to see whether he admits. Because simply saying chairman, is it the chairman of the appellate board that you have, or another chairman? You have to see.
Yes. So these are
Who's the appellate authority as per the listing rules?
board of directors. This part regulations
Appellate authority,
2010 50 rule 50,
board.
rule 50. The board where the chairman is the competent authority. and the chairman were any other officer.
Then who's the disciplinary authority? Anything mentioned?
Because I was the manager at that time. So disciplinary authority in respect of my disciplinary proceeding is the chairman, my lord. In the other subordinate staff, maybe the other head office manager, or they can be appointed in that way.
Anyways, that's a
Yes.
submission, let's say.
Yes, your lordship. So with the reservation to rebut the other side's counsel, my lord.
May it please your lordship. First thing first, your lordship, before I go deep into the other facts, your lordship, regarding whether there was any actual pecuniary loss, my the affidavit my learned friend had referred, I think, shown it clear, my lord.
Page?
Page 35, the affidavit that
Yes.
was allegedly executed by Zhou Sang Puya. Actually, Zhou Sang Puya at that time, my lord, was not the superior officer to the petitioner, my lord. They are both manager, but difference in their charge, my lord. Herein, Zhou Sang Puya at the relevant time was in charge of account section, your lordship. The petitioner, on the other hand, was fixed assets,
Okay, not superior. Okay.
not superior, lordship. And regarding actual loss was there or what, there or not, my lord. In his affidavit, my learned friend had read through, but not all of them, my lord. It is stated therein at paragraph number 3, my lord. At the end, last line of paragraph number 3 of the affidavit, lordship. It says, and subsequently misappropriated the amount in different accounts. So the question, the amount in question, 63 lakhs was misappropriated, lordship. That is why this is a very serious case, lordship. They, right from the beginning filing this petition, my lord, they keep on saying that that actual loss was not there, but this is there. This is their own affidavit, and on which they rely, my lord. So it says that it was misappropriated. That is why loss was caused to the bank. And number one. Number two, my lord, this Zhou Sang Puya actually was, if I'm not mistaken, terminated, my lord. And he also was involved in other cases also. And the stand of the bank, my lord, is that in collusion with Zhou Sang Puya, the present petitioner also involved in the present scam, my lord. That is why she had done the trickle feed account section authorization in collusion with Zhou Sang Puya. That is why she is involved, my lord. And this present, actually, this affidavit was only an afterthought, my lord. Since Zhou Sang Puya anyway will have to suffer and being terminated, and to save the skin of that petitioner, my lord, they, having an afterthought, made and executed this affidavit, which actually now is showing the real picture of the scam that they are involved in, lordship. So regarding the evidence, before I go into the judgment, my lord, evidence also, my lord, right from the beginning, the petitioner admitted of having done something which is not allotted to her, my lord. That is against bank instruction, my lord. So she had done something which she is not put in charge. She admitted that fact, my lord, but only saying that she had not done it having an evil mind, my lord. But the fact remains, she had done it. She had done the function which was not allotted to her, which was allotted actually to Mr. Zhou Sang Puya. But she had done it. Whether they may be request from Zhou Sang Puya or not, that is a different thing, my lord. The fact remains that she had done something which is against the bank instruction. And that resulted, my lord, in the pecuniary loss of 63 lakhs and 20,
63 crores,
yes,
63 lakhs.
Yes. That is why, my lord. Great pecuniary loss was there. And which was resulted from the action of the petitioner. That is an admitted fact, my lord. But herein, in her defense statement, she stated that she has done it only on the request of Jose Sangpuya. But that's a completely different thing. Whether it's on her own, that we cannot know. But it is very clear that she had done it, and she cannot deny it now, my lord. And regarding chance of hearing, my lord, if I may take lordship to all the proceedings enclosed by the petitioner herself herein, that it is clearly stated herein that in the hearing also, my lord, chance was there. She was given a chance of first written statement to file, and next she was summoned to personally
No,
appear.
so the submission of the petitioner is that it should be personal hearing.
Yes, your lordship. That was done, my lord. Done herein, my lord. Here statement is there, page 46, your lordship.
46.
Yes, your lordship. These are the proceedings of the inquiry conducted by the bank, my lord. PO is the presenting officer, and the CO is the charge officer, my lord. And question was put to her also. She personally answered to the question put to her by the inquiry officer.
No, but I think the submission was personal hearing before the disciplinary authority who had rejected the findings of the inquiry officer.
Yes,
Isn't
my lord.
it?
Yes, that is what.
That is his submission.
That, my lord, in her appeal, my lord, that was not there in her petition, if not mistaken, my lord, in the appellate authority, my lord. She has not asked for personal hearing, my lord. That usually is not done, my lord.
Okay. No, not before the appellate authority, the disciplinary authority. See, inquiry officer did his inquiry. Then the disciplinary authority did not accept the findings of the inquiring officer, the disciplinary authority. Okay. Now, the disciplinary authority had given show cause, but no chance for personal hearing. That's his submission.
And regarding personal hearing before the appellate, my lord, if I'm not mistaken, hearing also, my lord, the presenting officer also was not heard personally, my lord.
Okay. Now, what about the findings of the appellate authority? Just a few lines rejecting. Is that how the appellate authority is to record their findings?
Yeah, appeal is at page 62, my lord.
The order of the appellate authority is very short.
Short, yes, your lordship. Usually now they since rely on all the evidences taken during the inquiry conducted by the disciplinary authority, my lord. They usually are not very long, my lord. It is stated herein at page 68, my lord. This is the challenge, the one which they have impugned herein, my lord. In this connection, we have to inform you that the board decision in this regard, which is self-explicit as below, the board being appellate authority have carefully gone through the imputations of misconduct findings of inquiry authority, along with the comments of disciplinary authority, CSO submission and other related papers, documents, resolved to uphold the decision of the disciplinary authority. And now, my lord, then as my learned friend, I think, also had admitted that since the degree of proof required in department inquiry is only preponderance of probability, not beyond reasonable doubt, my lord. So I also have judgment to support that also, my lord. And what, my lord, I'd like to stress on herein, my lord, is that she herself, even before the disciplinary authority and in the petition hearing itself, my lord, admitted that she had actually done the one which she was accused of doing, my lord. But she only says that she had done it only in the request of the colleagues, Zosang Puya. Only that much, my lord. And that itself, her doing the thing which is not allotted to her is sufficient, my lord, enough for the penalty imposed upon her, my lord. And anyway, my lord, now as your lordship knows very well, in this kind of disciplinary departmental posting, my lord, the writ court, my lord, usually look into whether natural justice and fair chances have been given to the petitioner, my lord. That is only, not to the correctness of the decision, my lord.
So
For
we
the-
are seeing whether fair chances are given, because she says
Yes, Your Lordship.
it's submission is made that she was not given a chance for personal hearing. And besides that, another point which was raised was the disciplinary authority is also the chairman in the appellate board. Is that correct?
Appellate authority. That regarding that, my
Some
lord,
person looking into, you have to see, get some
I-
instructions, find out.
I cannot
Because
say it
see,
now, my lord.
let's have clarity on that. Because disciplinary authority is signed by chief manager.
My lord.
Chief manager and manager are same person or what?
No, my lord, chief manager is just conveying the decision of disciplinary, just conveying the decision of the board. So it was page 68 of the writ petition is the quoted sentence only, my lord, decision of the board.
So who are the members that consist of the board?
That also, my lord.
And
as of
whether
now-
the disciplinary authority is also the chairman of the appellate board, that has to be looked into, isn't it?
Yes.
That is the allegation made. If you want some instructions on that, we'll fix another date. Because that could be a point whether chance of fair hearing has been given by the appellate court or not. Same person against the same finding.
Regarding
cannot
that,
be
my
done.
lord, there is, I think, if my learned friend has conveyed to your lordship the regulation, isn't it? It is there in my lord. And very interesting, my lord, that regulation as of now, my lord, has not been challenged.
So in the, what's in the
it will
regulation,
be
does
there,
it
ma'am.
mention about the
No
same
need to
person?
challenge, my lord, no need to challenge this.
Otherwise, it
It
will
could be a
be,
different person, so just see whether it's the same person sitting or not.
my lord.
We'll continue in the next date, we'll make it. Well, how much time will you require? Because I think that is one pertinent point. If the same person who is the disciplinary authority also sits as a chairman of the appellate board, then can we say that it is fair, the appellate board's finding? Because it's his own finding.
We'll see, my lord, that
Yeah.
regarding that.
So find out, maybe he's not the same person.
Since it is one of my grounds, my lord. Because on perusal of the regulation, board of directors head is the chairman.
My lord,
That's
actually, that is not in the pleadings, isn't it?
No, so duty,
These are
board.
technical points, my lord, law.
It is beyond pleadings, I think.
Let's see, anyway, find out
My lord,
whether this is how it is. Discipline authority being the chairman, same
my lord.
person.
I have mentioned in my writ petition as well,
Ah,
para 23,
ah.
this particular point.
But if you need some time,
Yes.
appellate authority, the board, where the chairman is the competent authority, where the board, where the chairman is the competent authority, and the chairman, where any other officer is the competent authority. So here it has to be a different officer.
Yes. So
he might also be a member
50.
of the board.
yes.
So
That
what is 50? Wow. An appeal shall lie before the board, okay, where the chairman is the competent authority.
In the present matter, chairman is the competent authority. So it has to be laid before the appeal has to be laid before the board of directors. But board of directors is usually headed by the chairman. So it could be well
So the
presumed that-
chairman, where any other officer is the competent authority.
My lord, for an example, 52 says that If disciplinary authority is like the chief executive officer, not the chairman, then appeal should be before the chairman. But in the present matter, since chairman is the disciplinary authority, then appeal has to be filed before the board of directors, and I accordingly did that. And now the learned counsel has also said that it could be presumed that the
So
chairman
find
is
out
one.
whether
my lord.
this thing, appellate authority is again headed by the same disciplinary authority or not. Who is the chairman? Maybe the
We can have it
manager.
on 3rd
Yes.
July, Lord, next week.
Heard Mr. B. Ramena, learned counsel for the appellant. Also heard Mr. C. Zoram Chana, learned counsel for the respondents. Having heard the submissions made by the learned counsels, the learned counsel for the respondent has paid for time to get clarification regarding the constitution of the appellate authority in the instant case. In view of the above, list on when?
3rd of July.
3rd, 7, 2025.
Obliged.
Much obliged.